after the motion.
Pardon the mention. Lordship, the present petitioners are the drivers working on
When
the
do you
district
want?
judiciary.
When do you want?
Lordship, any day in the month of July.
But July we have difficulty.
August.
We'll put it in August.
First week of
So for second week we shall do. First week also is loaded already. Definitely.
My lord, August A4, writ appeal is not maintainable. Kindly.
You want the posting?
You want listed or you want listing? Sorry.
Listing.
You want listing now? Okay. When do you want? Which year matter?
24.
Showbiz.
Yes.
Okay. So in the second week of August.
I beg pardon, my lord. This is detail I paper listing in the month of August.
Which year?
2024, my lord.
24.
My lord.
If we take only 24, 25 matters, what should happen to the old matters? In the third week of August. Many will be in the queue. They will take the court that our cases are not
Fresh admission there?
My lord, fresh admission.
Not yet admitted.
Not yet.
admission.
Yes.
Admission.
That's surprising. Anyway, I mean,
Then
Yes.
we will tell them to post
all fresh should be listed. Actually, that's the instruction. They know it.
Yes. Yes. Sir.
Lord, morning actually I met an accident. So,
Is it?
my lord, I am turned 30 April.
Are you all right now?
No, I'm getting pain.
When do you want?
On Thursday, man.
Thursday. Not this Thursday. Thursday next week there.
Next week then
Yeah,
Monday.
Thursday next. Yes. Not this Thursday. Okay. Get well soon.
Page 2, 11 to 15. Page 3, 16 to 22. Page 20.
Lordship, item 22, Lordship.
22.
Lordship, item 22. To paper tweaks after for filing the rejoinder, Lordship.
2018 matter.
Lordship, I received the 25, received the counter of March, April 2025. Lordship.
All right. For filing of counter.
Counter. That is rejoinder.
I filed the rejoinder, Lordship.
Rejoinder, if any. Filing which right to file one stands for fetal. Call this matter in the third week of August. So, get the
Entry
request.
model is there, Lordship.
Entry model, if any, shall continue.
Lordship.
Page 4, 23 to 27. Page 5, 28 to 33. Page 6, 34 to 39.
38, my lord.
38.
Yes, my lord. Appellant's counsel's father-in-law expired.
Oh.
So I left Tortok yesterday.
Call after 2 weeks. At the request of learned counsel appearing for the appellant on the ground of demise in the family. Yes. But you can ask time without killing anybody.
No.
Yes. Yes.
Many times are they trying to repeat it.
Repeatedly also.
Especially
Multiple deaths.
especially.
Page 7,
Yes.
41.
I'm sorry, my lord. Item 30. Let me come on 23rd.
23rd.
24th is Thursday. I will go to Delhi. So,
Is it?
23rd or next Monday.
30th we shall have. Okay?
Page 7, item 42, Your Lordship. I am filing the rejoinder affidavit in course of the day, Your Lordship. I've served the copies. I'll file it.
It's ready now?
Yes, Your Lordship. I'll be filing it today.
Call after 2 weeks to enable counsel for the respondent to file appellate.
There is a petition.
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 42. All right, 2 weeks at the request of learned counsel appearing for the petitioner.
May I pray, Your Lordship, can it be taken on 6th of August?
6th of August. Very auspicious day. All right, 6th of August at the request of.
Item 41, man. Going for the appellant. The talk of compromise is going on. That is by instruction. 41.
41.
And
You want
they
time?
have filed a petition before the learned family court for mutual license. That was my instruction. I have asked for them the number and the position of the case.
Now the notice is sufficient on the respondent. Just come up with a noting that you are appearing today.
I have no instruction regarding the mutual divorce.
So we have to pass that order. If you mention, how can I pull out the file? Because
Sir, kindly wait.
or you instruct your learned counsel, see, we mention on your there, no problem. We'll mark your presence, no difficult.
Anyway, 2025 matter, just write down her name also. After when matter reaches, we'll pull out the file. Now it's very difficult. Files are piling up.
Date may be given so that I.
No, we will give you. Short while, long date we'll give you. Please wait. It is difficult to pull out the files, na? That's right. Yeah.
5 year lordships. I'm not.
We are calling that page.
5.
They are mentioned.
1
still
to 10
mentioned.
are not mentioned.
Anyone left in page
Yeah.
7? 40 to 45? Call the list.
Yes.
Item 1.
Ah. Yes. Obviously. The husband is working. The husband is complaining before this court against the.
I asked to Mr. Parija over telephone. He has some personal difficulties, so I prefer any other date.
In the 3rd week of August 25. At the request of. Sorry, just for the past.
Item 7.
May I please, Your Honor?
Yes, brother.
Well, the appellant has preferred this appeal against the order dated 24/7/2024 passed by the learned single judge, where the learned single judge has dismissed the case of the appellant for reinstatement of service on the ground that as he was a contractual employee, so no rights confer upon him, my lord. But
How many years he had worked?
6 years, my lord.
6 years.
Yes, my lord.
But it is contractual.
Contractual, my lord.
Then if it is contractual, once contract is over,
Yes, my lord.
you have to quit.
Well, petitioner's services are terminated because he was involved in a criminal case, my lord.
Is it?
Yes, my lord.
What happened to the criminal
Well,
case?
he was acquitted.
Was it honorable acquittal?
Honorable acquitted, my lord.
Read that judgment.
Yes, ma'am.
How the court below, how the learned single judge treated this contention?
My lord, kindly have a glance at page 23.
23.
My lord.
The acquittal came after or before his contract ends?
My lord.
Ended. You see, his contract ended on a particular case.
Yes, my lord. Acquittal came after, my lord. After, my lord.
So
Yes,
how
my
it
lord.
could have been
After 6 months, my lord.
So that also you have.
Well, there is a separate set of rules for contractual employees, my lord, which says even if no so
There is some. Suppose you are appointed for a period of 5 years.
Yes,
We'll
ma'am.
assume that.
yes,
Till 5 years, you are entitled to continue.
yes, my lord.
Is it not? On the principle of pacta sunt servanda,
Yes.
to which you have agreed, abide by it. During the 5-year period, if they want to terminate the service, then principles of natural justice.
Yes, my lord.
Okay. But if they want to send home after the 5 years, where is the question of principles of natural justice?
My lord, they have terminated my service on the ground that I was involved in the criminal case, my lord.
During the period of contract only?
Yes,
Or
ma'am.
subsequent?
During the contract, my lord.
What do you say,
My
brother?
lord, during the period of contract. But
Not
I was,
yet.
my lord, but I was acquitted
During the period of contract.
during the period of contract, my lord. But
When
I was
the contract was in operation.
Yes,
You were
ma'am.
removed from service.
yes, my lord.
On the ground that you were involved in
Involved in a
a
criminal case.
Is it true?
Yes. High
Any
one,
inquiry was held?
High one 2015. The contract was renewed because it was for 11 months.
5115.
2015.
Then you removed him when? On which date?
11 months after, my lord.
And
Then
20
now-
my lord.
My lord, in the meantime, they have indulged in this case, which is reading out, wherein subsequently he has been acquitted.
What is that criminal case?
Well, criminal.
Most of the cases get acquitted because of substandard prosecution. That is no ground.
Well, he has misbehaved with a, she has
Yes,
misbehaved
yes.
with a maid.
Page 28.
Maid.
Yes, my lord.
Then how to retain such people in the service? You have to send to the people where only men only are working.
My lord, the allegations were not proved in the criminal case, my lord. I was honorably acquitted, my
Yes, know
lord.
what is going to happen. Whole criminal justice system, well, less said is better.
But at least I should have been given the opportunity of hearing, my lord. And
What
plus,
opportunity of hearing? Your charge sheet is filed against you, trial takes place. Therefore, you have been removed from it. They say,
my lord, there are-
well, they have not renewed the contract. Suppose if you were an honest gentleman who will respect women, who will respect the privacy of other people, we can understand. A person who is having the criminal track record, okay, he might have been acquitted, but that does not clean the things. Therefore, we asked you, is it a honorable acquittal?
honorable acquittal.
Where is that observation?
My lord, so kindly answer page 23.
28 is the operating.
28 is the operative part.
28 will not be known. What is the reasoning of the trial court in the criminal matter?
Lord, so kindly have glance at page 28.
28.
Yes, my lord. Second para, my lord. So far as the allegation for offences under section 323 IPC against accused Dr. Ambika Mahapatra is concerned, there is almost nothing on record. The victim is completely silent on this aspect of the prosecution case. Maybe the medical officer has noticed series of injuries on the victim by his report. In the absence of clear evidence that accused Dr. Mahapatra is the author of these injuries, this court is not in a position to accept her guilty. Likewise, there is absolutely no evidence with regard to offences under section 344, 374, 506 of Indian Penal Code. There is also nothing on record that accused Dr. Mahapatra, being a public servant, engaged the victim, a member of the scheduled tribe for compulsory labor, for which this court is not in a position to accept this part of the prosecution and constrained to hold that the case under section 314 and 327 SCST PA Act must fail, my lord. On close analysis of this entire evidence, this court is constrained to observe that the prosecution has failed miserably to establish its case beyond all reasonable doubt.
Then P.V. Rudrappa appears against you.
But in the results, Ayush doctor.
Ayurvedic
He is
medical
doctor
doctor.
under the NRHM scheme, which is meant for 11 months and
Who
subsequent
was the victim at her hands?
one patient.
He's a male.
Oh, man, a lady.
Nine, female.
Another lady.
Yes.
Doctor is a
Lady doctor. Lady doctor, man.
Female.
Yes, madam.
Lady doctor versus lady doctor. Two doctors fought with each other.
No, madam.
He is a patient.
Patient, man.
Patient. She, instead of treating the patient, ill-treated the patient.
Yes, my lord. My lord, SCST Act and all, my lord, they have used against her, my lord, intentionally to.
There is a apex court says the Procedural Act is being abused. So take notice, let us see. It requires consideration because apex court said the Atrocities Act is being abused by many. Do you have that judgment with you?
My lord,
This is fine, because you want renewal of the contract or you want re-engagement, what you want?
re-engagement, my lord.
But by the time
So,
contract was over.
My lord, when I was terminated, my lord, the contract was in force.
Is it your case?
My lord,
I hope I can make you
This has been
say
clarified.
something to
yes, madam.
Is it your case that this casts a stigma upon your re-engagement?
No, no.
Because re-engagement could not have been your prayer as far as, because they say that contract period is over and you have exhausted the entire period.
My lord, when I was terminated, my lord,
Correct.
the contract was in force.
So contract was in force. After that, suppose you are now re-engaged. So how much period is, he said it is 11 months, 11 months over.
Because
so
when-
maybe it is for 1 month.
Well, after
Do
6
you
years,
want further 1 month engagement or re-engagement
re-engagement, my lord.
for the entire tenure, whatever possible? So the
Yes, ma'am.
prayer would be different. You look at your repetition prayer.
Lord, because contractual employee, my lord, after 6 years of service, my lord, they are deemed to be regularized. They are deemed to be regularized, my lord. Here, my lord, there are only
Deeming provision for regularization is for regular engagement, not contractual.
contractual employee. As for 2013 contractual rule, my lord.
2013 contractual rule says all regular employments will be contractual. And not for doctors also, there is no this kind of.
My lord, similar situation.
This is not.
Similar situation.
Look at that 13, it starts with for Group C and Group D.
Only Group C group.
It is meant for Group C group.
No, it is
It is also
he must be aware. He practices in this.
It is also there for Group B employees, my lord.
Don't bring that for a Group B or a Group A service.
For Group B also it is there, my lord. Group B 2013.
So there all these vacancies are deemed to be contractual. All appointments, regular selections, but that has now been abolished.
2022 rules have come in, my lord.
Yes. So basically, in your case, whether this engagement was under
13 rules, my lord.
So that you have to make out that case.
Well, as I was a contractual employee, my lord.
Not Group C, Group D, sir.
Where are they? No, doctor is not Group C group.
They are in a project and doctors under the.
They are under the scheme, but the employees who are appointed under the scheme, they are also been regularized after 6 years. They are also been regularized after 6 years, my lord.
And which is the rule?
My lord,
Which rule? Where have you put it? Where is the pleading?
the rule is, my lord, contractual appointment rule 2013, my lord, in respect of Group B employees, my lord.
Where not stated in the petition? And so you have to show that you are employed under that scheme only, that rules only.
My lord, I was appointed under a scheme, that is NRHM scheme, my lord. I was appointed under National Rural Health Mission scheme, my lord. But I have continued for more than 5 years. Thereafter, my lord, I was convicted thereafter I was involved in a criminal case and my services are terminated when the contract was in force. But my case before a lordship is, before terminating my service, my lord, they should have given me a fair hearing, because there are several judgments of this Honorable High Court which says that even if you are contractual employees or schematic employees, before terminating your employment.
That's right.
Principle of
an
municipal justice has to be
hearing
followed.
is a must.
Yes, my lord.
But suppose if your rules provide for termination on the ground that you are facing a criminal case.
Yes, my lord.
Whether rules provide for that?
My lord, criminal case has to be proved, my lord.
Conviction has to happen.
Yes, my lord.
Look at the contract. Place your contractual engagement order where or the contract itself.
Yes, my lord.
Where is that? Which page?
That is Annex 1. That. Lordship, kindly have page 18.
Writ petition or writ appeal?
Well, writ appeal, page 18.
18.
Page 18, 9 is termination.
Case of improper conduct of the second party, the compensation shall be paid. I think we should have understanding that already.
So it doesn't refer to anything. That 13 rules are
notwithstanding, come to notwithstanding clause.
Notwithstanding anything contained herein above, the services of the second party may be terminated of time by the competent authority of the society if the second party is found to be involved in criminal case or criminal offense.
Involved in criminal case means what? Conviction.
No, my lord.
If you are involved in a criminal case,
offense or
we don't want people who have potential of fighting. We are here to do the government job. We don't want litigious people, unnecessary headache people. That is the object of clause. It does not say on conviction. If you are involved in a criminal case,
or guilty
charge sheet is filed and the trial takes place. Maybe you are acquitted.
Yes, my lord.
But that makes no difference.
Look at paragraph 2, duration of agreement. That is what Mr. Mahanti was saying. Look at.
But my lord, the contract was there.
The answer could not be but for my lord. Can you look at it?
Yes,
I don't know what is
yes,
happening.
sorry, my lord.
If you say that I am not supposed to interact with you, you can very well say.
Sorry, man.
You should be sorry. You are court of law. 16. The duration of the agreement shall be 5th January 2015 to 4th December 2015.
Yes. No, my submission before your lordship is
so where you have based your claim, that's the point is when you are arguing a matter, you have to base your claim under certain legal documents. Certain rights and liabilities, whatever they accrue. So by simply saying, coming here and saying that I expect to be regularized, fair enough. But your expectation for regularization emanates from which document? And involvement in a criminal case, whether would amount to termination or not. That's the second aspect.
Yes, my lord. Only, my lord, involvement.
So the interaction with you is because whether this, if you say that this termination was stigmatic or non-stigmatic for future engagement, that can be a residuary.
We can make it clear that it will not be stigmatic.
But my lord, by this time I have become overaged, my lord.
But what
I will not be appointed anywhere.
But no court can grant stay to the
And petitioner is a lady doctor, and false allegations were made against her, my lord.
Therefore,
False allegation of SCST Act and atrocity, all.
we do not know.
And similarly, my lord, similarly situated Ayurvedic doctors of Ayush, my lord, their services has been regularized.
Identical.
Yes, my lord, identical, my lord.
Where have you pleaded that?
But I pleaded, if your lordships give me time, my lord.
No, have you pleaded that?
I have pleaded, but I have not given any documents to that effect. My lord, if your lordship allow me, my lord, I will.
Where you have pleaded, that's no prayer actually.
Yes, my lord, prayer.
The best of my efforts I have searched, that's no prayer for regularization of your services.
So what we can do is checking what is research and that's what it is. Is a tentative one. Not been issued.
No, my lord. First time it has come open.
Issue notice. Learned AGA, Mr. Mohanty, is requested to accept notice for the respondents. All respondents?
Yes, ma'am.
All right. Whatever repair and other things you have to do, you have to do.
Yes, ma'am.
But you argued well. Yes.
Feel encouraged. I mean, don't hesitate to interact with the court. With if I may say so, that was the assumption that the court is against you.
No, madam.
We are not against anyone. Nor we are in favor of anybody.
You can make a watertight case, it becomes much easier. It's always on the converse actually.
Grateful, madam.
Okay.
Item 8.
May I please, Lordship?
Yes, sister.
Lordship, my appointment as Panchayat Secretary rejected on the ground that there was a government notification for abolition of such post, Lordship.
Yes.
But Lordship, my humble submission is that the notification was dated on 15/10/2003, Lordship.
That abolition of post.
Yes, Lordship.
16/10.
15/10/2003.
15/10/2003.
But my appointment was, Lordship, that is 26/6/2002.
26/6/2002. Yes.
And that appointment was stayed because of status quo order of this honorable court, Lordship. That is on 37/2002. But subsequently that order was vacated.
No, if a post is abolished,
But
where is your right?
Yes, Lordship.
Have you challenged abolition of the post?
Yes, Lordship.
Abolition of the post also you challenged.
No, Lordship. I am challenging my, but that abolition is not applicable to me, Lordship.
How?
Lordship, kindly glance this on the single honorable single judge judgment is contrary to the judgment of this honorable court in WPC number 6579 of 3, 7036 of 3, and 8703 of 3, Lordship.
Just means, sir, we have been taught by Ramajais that where post is abolished, your appointment comes to an end.
That may be, Lordship, but that post, abolition of that post is not applicable to me because I was appointed before that, Lordship. And
naturally, you have to be appointed before that only.
And
before abolition.
Yes, Lordship.
Naturally, if it is abolished, with that abolition, your employment comes to an end. That's what the FX court has said.
My humble submission is, Lordship, kindly glance at that judgment, Lordship.
Which judgment?
Because Mahanti actually, we've gone through that. Is it on record that 15/10/2003
abolition,
abolition, which leaves any post not to be abolished, because your argument is that the person being appointed on such and such date is out of the purview of that particular abolition.
That's your case.
That's your case. Very well, that's a good argument, but you have to substantiate that.
Because Lordship, my
So kindly look at that 2003 abolition.
that is 15.
You see, you initially the matter was disposed of without being considered on merits.
Yes,
The
Lordship.
representation you to be disposed of.
Yes, Lordship.
The representation is disposed of,
We're rejecting.
rejecting it based on that 2003 resolution. The query from my lord is that whether you have challenged 2003 resolution. Your answer is no, but you are excluded from the purview of that 2003 resolution.
Yes, Lordship.
So now please show us that 2003 resolution has a, has a leeway for you to being not yourself. Post survive the 2003 resolution. The short, long and short of the your submission.
Yes, that one
Can they
also.
show that? Can they show that?
16.
That post was also redesignated, Lordship. That was the counter affidavit filed by the opposite party.
Post is redesignated.
Redesignated.
Which is that, which document you are reading?
Lordship, kindly glance at the judgment, page number. That is 14, Lordship.
1-4.
Yes, Lordship. May I place it, Lordship?
Transfer of the retaping.
Yes, Lordship.
So your case is that after redesignation, whoever was there as a government secretary, he continued in the redesignated post. Post abolition, after abolition.
Lordship, they redesignated the VIL, that is voluntary, the
Village level work.
that is the
VLW.
Lordship.
VLW was
Yes, Lordship.
secretary is redesignated as VLW.
Yes, Lordship.
So what happened to the persons who worked as that in that post, as GP secretary, which you were holding?
Lordship, they are continued.
Where have you stated? You have not stated that. It is not your case. 1,401 posts have been abolished. And unfortunately, the post which you were working against is one of them. Therefore, one post is abolished. See that judgment, learned single judge has rightly said. He has rightly said, when post is abolished, the question of appointment remaining intact would not arise. Ramanatha Pillai versus State of Kerala, PIR 73, Supreme Court.
Lordship, that aspect was also taken by this honorable court in WPC number, that is Lordship 6579 of 2003, Lordship.
Where is that?
That judgment, I have that judgment, Lordship, but I have not.
Give that copy. Same aspect was stated by other bench.
Yes, Lordship.
If you have continued a section of people, then you can't say that to others, no, we have abolished the post.
Here, my lord, so far the present appellant is concerned, he could not fulfill the submission of the documents which is required for his appointment at the initial stage. Subsequently, that appointment is being challenged by another person.
Status quo was there.
Exactly. So status quo was there.
Then what happened?
When it was disposed of, then file another application. This is the third round of litigation. Then by that time it was abolished, and subsequently by redesignation it was on PEO, Panchayat Executive Officer.
That post is redesignated.
Exactly.
Then she is entitled to.
No. Prior to that it was abolished in 2000.
Mahanti, you have given the fresh lease of life. You have put the service on ventilator by rejecting it that it is abolished. Beyond that, you have not discussed anything.
Is it abolished or redesignated?
You look at the order challenge in writ petition.
Question is, Is it abolished or redesignated?
Abolished.
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 But you used the word
My lord, subsequently, after merger of the same, they have redesignated the post of GPS to PEO, Panchayat Executive Officer. But the present appellant, who is the petitioner in the earlier occasion, my lord, he could not be appointed because of the non-submission of the document at the threshold.
But that judgment, earlier judgment also stares at you.
They consider the
Yes, did the court say that?
representation.
And your ground of rejection is, suppose those 1400 posts are abolished.
Yes.
But the persons who are continuing as in GP, the secretary, GPS, they are redesignated according to you as
PEO.
Panchayat Extension
Executive Officer.
Panchayat Executive Officer.
Executive Officer.
So this secretary becoming executive officer is a fact. So how do you say that?
But the person has never been appointed.
His rights got extinguished on the date when the post was abolished. That is your simple case.
Yes.
But it's not that simple.
But he could not.
No. It requires consideration. Because you have continued other people also. That's what sister told me.
He has been telling that.
Issue emergent notice. Learned AGA Mr. Mohanty is requested to accept notice for the respondent. Share your copies with your friend. Yes.
Item 9.
Oblesner.
Item 9 on behalf of the Guru Dutta Kara.
Respondent 4 take notice. This is Mohanty, Grama Panchayat, you have to take notice.
Or separate advocates.
So Gram Panchayat, they don't appear. This Mohanty will appear for the Gram Panchayat.
And they have their own.
One advocate. Then for state you take
For 1 to 3. So 4 is to be, notice is to be issued for 4.
Emergent notice to respond number 4.
1 to 3, I can.
1 to 3, Mr. Mohanty. Emergent notice to 4. Request to be furnished within 3 working days. Yes.
Item 9.
Item 9 on behalf of the Guru Dutta Kara. Some person with difficulty not attend court today. Kindly urgent one no captor.
Call in the second week.
You have to read. Constitution is always asking that whether you have looked at the brief or not. What is the case?
What is the case? At least few sentences you have to say.
Illiteracy matter.
Huh?
Matter against the Tata Power. Illiteracy matter.
Electricity matter. Anybody is given electric shock.
That's
The second week of August.
Recommendation of NOC, Your Lordship, for the current session, 2025-26.
Academic matter.
Your Lordship, academic matter.
What is the ground on which they said will not give?
One is the first item. No complete geotag photo of each building has not been submitted. And as per the DFO letter, the fire safety certificate has expired.
What is the intake capacity? What is this course about?
It is about, Your Lordship, BSc.
BSc nursing.
BSc nursing, Your Lordship.
BSc nursing.
Your Lordship.
Degree.
Yes,
Degree.
yes.
Your Lordship.
Yes. Complete requisites have not been given to you. To accept, take notice and
Yes.
issue emergent notice. We have
24th, Your Lordship. 24th.
24th disposed.
24th of July, Your Lordship.
Is requested to accept notice for 2 and 3. 2 and 3. First,
State.
Mr. Mohanty on request and subsidies for the first respondent, first term. All this matter on it.
Have you complied that?
Your Lordship, I have complied.
Have you informed them?
Your Lordship, I have informed them, but they have refused to accept the hard copies.
I will take the instruction.
It is submitted by the Lord Counsel for the petitioner that after the report of your OP number
2 and 3.
2 and 3. 2.
State Council.
DMET.
After the report of the OP number 2 and 3 regarding certain deficiencies, they have complied the deficiencies and intimated the authorities for their acceptance, which were refused. The Lord Counsel for the opposite party number 2 and 3 shall also obtain instruction. Pendency shall not be a bar for consideration of the compliance reports, if any, by the petitioner regarding the deficiencies pointed out earlier.
Explanation of delay, and delay was condoned subject to condition of making certain payment. First, that's all. This application at hand now is moved by the state seeking recall of the above order, contending that the delay having already been condoned by the apex court itself in the subject SLP, subject SLP, the question of condoning delay would not again arise. First of all, Mr. Mohanty rightly submits that had the delay not been condoned by the apex court, it would not have remanded the matter at all. First of all, we agree with this. Next paragraph. In the above circumstances, the order dated so and so, whereby delay was condoned, and the appellant was directed to make payment to the respondent. 36/2025 stands recalled. First off, we again say that delay is already condoned by the apex court, and therefore appeal needs to be taken up on merits.
Yes,
How many matters are there?
already that time has already been over. From November 2024, Honorable Supreme Court directed.
That's all right.
Yes.
But how many matters of this kind are there?
Only 2 matters.
Both matters.
You tell which date you want.
And please give the list today. Mr. Behra, your matters, if you are aware, give the list. And
Honorable Bihari Mahanti, in that case, Honorable Supreme Court directed that Honorable Bihari Mahanti case and this Badrinath Rautra case.
One is of Honorable Bihari Mahanti, another is of Badrinath Rautra today.
Only two cases.
2 matters of my last friend.
But there are maybe other matters. But at least your matters.
Let him take instruction. I can also take the instruction.
My matter is that Badrinath Rautra, only one matter, man.
Yeah, only one matter.
Yes.
Other matter is what? Which is?
Other matter is my lord.
Bihari Mahanti. That Lawrence Senior Buddhadeva Rautra is happening.
Call this matter on.
This can be posted to which date?
This case is 22nd July.
22nd July.
The Atal Bihari Mahanti case will be listed along with this case. So your lordship on the last directed that to be listed.
The date was fixed in this.
22nd July.
Call this matter on 22nd July 2025. Well, along with this matter. Along with this. No, along with not this matter. We are making order in this matter.
We are directing in Badrinath, right? We will list down the
So it has the W 904 of 2024.
904 of 2024.
23.
It cannot be 22, no? It could be 20 because of
160.
Okay.
Nice.
Yes.
Nice.
Item 12, 14.
That is the option.
The President patent appeal is arising out of an order passing FAO.
We have one request. We think that you are instructing counsel to him.
Yes.
You are opponent.
No, you're not.
You are instructing counsel.
No.
You are not consulting the case at all. Okay.
They are discussing the writ appeal number.
Okay.
Because in another writ application, mine.
They are discussing. Very well.
So this appeal is arising out of an order passed in FAO. That is the first appeal against order passed under Order 24C of the Odisha Ejection Act 1969.
What is that?
And so one difficulty is there, Lordship. As per the order passed by the division bench, earlier division bench of this Honorable Court.
Make use of the mic.
I'm sorry.
Everybody will hear your voice.
As per the earlier order passed by this Honorable Court.
It is not put on. Mic is not put on. Then you go near or grab that mic near you.
So you lift it to your right.
It's already stick.
Lifted. You are tall person.
They are pested.
It's pasted, Your Lordship.
So you get pested to the man.
As per the earlier order passed by this Honorable Court, I have filed this writ appeal against an order passed in FAO number 739/2018. The judgment is there, Your Lordship. Now, what difficulty is that subsequently the case. The order passed by this Honorable Court has been overruled by a larger bench, where it has been stated that against FAO, no appeal is maintainable.
So that larger bench kindly give the reference.
That reference I have tried to search, Your Lordship, it's not uploaded yet.
No, it is there. It is uploaded. I mean, nowadays uploading is instant.
No, I has given that order. Month he has given that order.
That I have supplied, my lord. Today also I can supply.
Please.
Appeal is not maintainable.
Yes, Your Lord.
Intra-court appeal is not maintainable. Because it was under 227.
My lords.
So that way appeal has to go.
My lords.
The limitation to be saved for taking the matter to the
Supreme
other court.
Yes.
Learned counsel appearing for the appellant in all fairness, in appreciable fairness, submits that in view of full bench judgment of this court in so and so, comma, an intra-court appeal of the kind would not lie, in as much as the order impugned before the learned single judge was of the education tribunal,
State education
tribunal, and therefore obviously was under the challenge was under Article 227 of the Constitution of India, comma, other provision, namely Article 226, having been ornamentally employed in the pleadings. First, we agree with this. Next paragraph. In view of the above, this appeal is disposed of as not being maintainable, reserving liberty to the appellant to tap the jurisdiction of other forum in accordance with law. And in that connection, all contentions of the parties are kept over. Next, the party needs to be observed that the period spent prosecuting this appeal to be liable to be so while computing the period of limitation for taking up other matters, other challenge.
And kindly give the reference.
I will give that reference.
Give it in writing.
Or I will also supply. I will try to supply.
Very. Thank you.
Great.
Yes, sir.
Copy to be given.
Item 15.
Yes, sir.
This matter allotted to Mr. Hon'Ble not AGM, he is suffering from viral fever marriage.
Call in the third week of August on the health ground of arguing.
I am appearing for the.
Yes, third week of August, you have difficulty?
Can I pray for an
First week. First week.
Because, my lord, it's a case of regularization where, my lord, your lordship will find that this very same issue has already been set at rest by the division bench of this honorable court, which went in appeal by at the behest of the state opposite parties, and that
30th July we will have that. 30th July.
Item 16.
Item 16 may please, Lordship. Here, Lordship, the writ appellant is a society under the Ministry of Defense, Lordship. And the order...
Society under the Ministry of Defense. Means it's a government society.
Society. Chinese school society, Lordship.
Okay.
Here, Lordship, at page 22 is the impugned order passed by your learned single judge, Lordship. And the issue is that, Lordship, the present opposite party being found guilty in a disciplinary proceeding, that is a court of inquiry, he preferred an appeal before the authority, the assigned authority. There the appellate authorities heard the matter and signed the order. Now that became the point of dispute by the present opposite party, saying that the person who has heard the matter has not signed the document or the order. That became the point.
Some other person has.
Other persons. That is what the contention before the Honorable Single Judge. And what happened, Honorable Single Judge held that as because there was a specific direction by this court that the person who will hear the matter, he has to sign the order. So accordingly, that order satisfied and directed this present appellant that you again give a re-hearing to this opposite party.
De novo
hearing, all these things. Now,
in the hearing, in the appeal or in the original proceeding?
Appeal. Here, Lordship,
so it is in your favor?
No, it was not in our favor because
partly in your favor. You are given that chance to rectify the mistake.
Yes, that's true. But here the case is what I'm trying to impress upon your Lordship is that
same authority has heard and same authority has passed the order.
No, not in that way. In fact, Lordship, if Lordship kindly permit page 51 of the brief. That is 51, 5-1.
Go to 5-1.
5-1. Here, Lordship, the last para of that impugned order, appellate order, there, Lordship, I may read, Lordship, that para 27 is the last one. This says, this issues by the order and approval of the Honorable Raksha Rajya Mantri, that is RRM, and Chairman, Board of Governors of Sainik School. And the signatory is Joint Secretary, Honorary Secretary, Sainik School. As per the rules and regulation of the society,
one question.
Pardon.
This 51 is result of the hearing or it is the issuance of order?
Result of the hearing, let's see, of the appellate by the appellate authority. Here, what happened? The RRM, the Rashtriya, that is
the hearing according to you. Who heard the matter?
That is Raksha Rajya Mantri was the chairman, and he is
ex officio chairman of this society.
Yes, and he has to hear the appeal as per the statute for the society norms, and he had heard the appeal. But as per the approval and direction, that is the provision under that rules and regulation of the Sainik School. I bought the book. I will supply it. There, this assignment can be given to the Joint Secretary, where the Joint Secretary will sign the document.
Sign or hear?
No, will sign the document because the hearing will be done by the appellate authority. That is the RRM. That is Honorable Raksha Rajya Mantri.
In other words, what you say, regardless of who signs, the hearing has taken place by the same person who passed the order.
No, just opposite. RRM, the Rashtriya Raksha Rajya Mantri, is the person is called appellate authority. He had heard the matter.
Well, Lordship, you said that only. Why you are saying that?
I may be misconceived.
No,
so the other
irrespective of who was signed, but the hearing was made by the RRM. Honorable Raksha Rajya Mantri, and the order was issued as per his direction.
By him only. Only thing is formally it is signed by other person.
And Lordship knows that is the theory of authentication is there, and everywhere it is being followed. So this is how the only thing for which repeatedly we have been directed that to go for give a de novo hearing. The same thing is being repeated, and for that reason we have also faced a contempt proceeding.
Of the single judge. Regarding that who held the hearing,
Lordship.
Any finding?
Lordship.
Is there a positive finding that
Minister
Raksha Rajya Mantri never held that hearing? Is there a finding?
No, Lordship. Learning page 28. May I read letter?
28 of internal page.
Learning page 28. Internal page is page 7, Lordship, of that impugned judgment.
We have been taught in the administrative law by my professor, Professor Viswesvaraya, Dr. Viswesvaraya. He used to tell us, he used to quote one famous statement, Sri Krishna cinema versus so and so, so and so. I may be wrong also. The principle is, hearer should decide the matter.
Right. As always.
That's what 91 Supreme Court, Ramzan Khan versus so and so, where if he does not hear, then you have to take the report you should give copy of the report to the delinquent employee. Have we say over the matter? Then the disciplinary authority would decide that matter. If you demonstrate, person who heard the matter decided it, then case over. Who signs is very, it pales into insignificance.
Right.
It just shows that who heard the matter. For that, we need the records.
Lordship. Running page 28, para 6 is relevant.
That's what the judge also has held that way.
The Honorable Single Judge held that it was a specific, may I read the relevant portion, if permitted.
Even though pursuant to the said order.
Lordship, I am reading out also. Even though pursuant to said order, opposite parties bear the cost, but as found from the impugned order has been passed not by the appellate authority, but with an observation that the same has been approved by the chairman, Board of Governors, and Raksha Rajya Mantri. Since this court...
So, may I stop there? That's a finding. What is the basis of that finding that it was not by the appellate authority? How the court arrived at that conclusion, according to you?
This same, as my lordship was telling, that is a person who heard the matter, he has to sign the document. That is the fundamental. Now, based on that,
he hear the matter. Next line. He directed the chairman board of party number 2 to rehear the appeal and decide the same in accordance with.
No, the discussion would be above 6.2. 6.2 is the conclusion.
Let's see.
The issue is where the court has dealt with that aspect, that who heard the matter from the as it is appearance as or to appear from the materials on records.
Lordship. Lordship, I can read paragraph 4.3. If your lordship permit, I may read page 26. Turning page 26, it's paragraph 4.3 is available.
No, so much story may not be necessary at all. If you demonstrate that it was the Raksha Mantri who had heard the appeal and who passed the order, you show that. If he had heard and passed the order, he would have signed the document.
He should have signed.
He has not.
Yes, he has not. He has delegated the power to the Joint Secretary as per the norms.
Power to sign.
In your records, what is there? Lordship is asking.
Lordship, Annex 3, Lordship. I have annexed the document.
Power can be delegated is one thing.
Lordship.
Power to sign is being delegated is another.
That is what I am demonstrating, Lordship. I have brought the books for Lordship convenience. I am placing one by one, Lordship. How this joint honorary secretary has been given the authority, that I am demonstrating from
just the. We're not disputing. We're not disputing. One.
Literature say?
Lordship, I am passing.
Just read. We believe you. We have no reason to doubt you.
Here, Lordship, I am relying on this Municipal Society rules and regulations, Lordship.
Is it the Article 12 entity?
Not exactly. It's not in that way, Lordship. It's in fact, it's.
No, if it is not Article 12 entity, then how writ petition was maintainable?
That was.
Sainik School is Article 12 or not entity.
In fact, it's not.
It's not?
No.
Did you take up that contention in your
objection? No. In date appeal, I have no scope because in that.
Not in date appeal.
Counter, it was not there. I was going through the counter, but it is not.
But you have to check the law. I think a lot of petitions are filed against Sainik School.
There are some petitions are pending also.
Because you are discharging imparting of education. How this court has held.
That is not been.
Okay.
Yes.
If a society is established by the government, then ordinarily it is an Article 12 entity. If a society is established by the government, it will be an Article 12 entity. I think B.S. Minos versus Statistical Institute.
Subsequently, St. Mary also.
St. Mary also.
But St. Mary is not established by government.
Yes, sir.
Indian Institute of Chemical Technology. That's a Biswas.
But the contention they have not taken up at all.
There is
so
not.
It is a state. It would be Article 12.
Fine.
But that is minus in the comment.
Anyways, that's all right.
Anyways,
Now just read what is the procedure of doing things there.
how it has been done and how we are relying upon. That I'm trying
Can
to
you read that?
Lordship. Here, Lordship, I am relying on the chapter 7, that is called Terms and Conditions of Services. There, if Lordship can see, I am reading out. That is clause 7.09.
Read.
The last three
Read.
Yes, I am reading aloud. The affected member of staff shall have the right to appeal to the chairman, board of governors, who may dispose it of himself or direct a nominee of his to dispose it of. That is there in that provision.
He can delegate it to some other person also.
To dispose of. That is what the interpretation.
Either he himself will dispose of, or he may delegate that power of disposal to some other person.
Direct and nominee, that is the wording? No, correct. That is there. This is one thing, Lordship. Second is, Lordship, Appendix B at clause 16, I am relying. There also, this chapter starts, that is what is the role of an honorary secretary, who has signed that one. The role is very simple, says, the honorary secretary is directly responsible to the chairman, board of governors in all matters connected with the administration of the Sainik schools.
But this does not come administration, it comes into conduct. Conduct, because for that you cannot go, because this is a matter relating to conduct of an employee. Right of appeal is given to an employee. That power to decide appeal is with the minister, and here power to delegate on. We have one doctrine. Delegatus non potestas delegare.
Right.
We have one doctrine, and it may not be applicable.
This point never failed for adjudication, that whether he was competent to issue the order or not. You are relying on this particular provision to show that the joint secretary was competent to issue the order on behalf of the Raksha Mantri.
No, that is not so.
So, but the court gives a finding that somebody else had heard the matter who is not designated to be the appellate authority to decide the matter.
Right. Because they are
that where is the finding? Anyway, you have maybe you have to produce that.
Produce the original files.
That I have annexed, Lordship. Annex 3 is the
original is produced.
Or it is there as photocopy, Lordship.
Photocopy is produced.
Three in the writ petition.
Read appeal, Lordship. Here, Lordship. Annex 4, pardon, Lordship. Page 42 is the starting page. 4.2 is the page starts from 4.2.
So why do you demonstrate that the Raksha Mantri, Raksha Mantri has passed the order in the file? Why do you say that?
Lordship.
See, this is the order communicated. Annexure 4, what is the impugned order before the learned trial, single judge? It's the communication.
It's a communication.
So 51 says, this issues by order and approval of the Honorable Raksha Rajya Mantri, RRM, and Chairman Board of Governors. So that part is fine. Your argument is that this is the issuance.
Very short point is whether minister passed the order or someone else has passed the order. If someone else has passed the order, was it the designated authority? That you can demonstrate from the record.
Right.
So Gullapalli
Nageshwar Rao state of APSRTC.
Second
Gullapalli.
It's upheld order that minister
because that passed communicated. That's what. The transport matter. Transport
Gullapalli is what the
and page 45%, that will show that the RRM has had the matter. Justice asking the question.
No.
Who has had the matter?
Not court is asking you, because that's your argument.
Yes,
so that is the first argument you should make.
In Gullapalli Nageshwar Rao versus APSRTC, the apex court said, one who hears should decide the matter. If we can show from the records, person who has signed is the person who has heard. End of the matter. Why we should spend so much time in this?
But I am trying to demonstrate before that by
regulation from the records.
You are yet to demonstrate that.
From the records it should be. Rule position you have demonstrated.
Right.
Whether those rules have been followed or not, that can be demonstrated by looking into the records. You produce the records, then we will consider. Appellant, having argued the matter for some time, is directed to produce the original records for our perusal.
Right.
Regarding the hearing of appeal.
Concerning hearing of the subject appeal by the minister.
Right.
and order being passed by himself, although it is signed by his nominee.
I'll produce.
Non-production may result into an adverse inference being drawn against the appellant. Call this matter on 5-8. Simple matter. It takes a lot of time.
I will look at it.
Item 17.
Bring that Gulapalli Nageshwara number 2. There are series of Gulapalli.
Item 17.
Yes, sir.
This appeal arises after
Rajesh Mahapatra, you are CGC or senior panel?
Senior panel.
Mr. Mahapatra, you argued well.
Yes.
Senior panel counsel.
And next under 6 is under challenge, madam. What happened, madam? The one advertisement was issued under Annexure 1 for the post of Secretary of the Kiazhar Service Cooperative Society Limited, madam. And accordingly, the petitioner along with others and the appellant along with others have applied, and thereafter, my lord, after scrutiny, a list was published wherein the respondent number 1 placed at serial number 1.
So, Aguru, why you were agreed with the order? Which part of the order you were?
What happened actually, the respondent number 7 approached this honorable court under Annexure 4 for the first time, and wherein the honorable single judge directed to dispose of the representation matter. Thereafter, the authority considered the representation of the respondent number 7 and rejected his representation. Thereafter, he came before this
representation, praying for what?
Praying for consideration of his MCOM certificate, which was not given at the time of before the cut-off date, last date of application manner. Thereafter,
MCOM is the qualifying education.
Yes, ma'am.
Master of Commerce.
Yes,
is the qualifying.
No, madam. Qualifying qualification, minimum qualification was graduate, madam. Become.
This is additional attraction.
Yes, madam. There is a clause, madam. If higher qualification is there, he will be awarded additional marks, madam.
You did not produce it in time.
Madam, I know. The respondent number 7.
For the employee.
Respondent number 7, madam.
Respondent 7, private or employee?
Private employee, private candidate, madam. Respondent number 7 did not produce the certificate along with his application by the cut-off date, madam.
But subsequently he produced.
But subsequently he approached before this honorable court under Annexure 4, wherein this honorable court directed to consider his representation with a reasoned and speaking order, madam. And thereafter, the authority rejected his claim. Thereafter, he came before this honorable court under Annexure 6.
Mark sheet was produced original.
Madam, mark sheet, as per his averment, he had produced the mark sheet. But in the...
As a matter of fact, what was the consideration by the selecting authority?
This is under Annexure...
MCOM mark sheet.
Yes, it is under Annexure 5, my lord. They have stated that Prakrutar MCOM certificate
certificates being issued at a substantial time lag.
Yes, madam.
At times it is 10 years, 15 years.
Madam, advertisement was in the year 2008.
Certificates.
Yes, ma'am.
Certificates issued by the university.
Certificates are not issued in time by the university.
Yes, ma'am.
So, therefore, mark sheets is given. Subsequently, a certificate has been issued that tallies with the mark sheet.
Yes, ma'am.
What is
the in the second round litigation, when the respondent number 7 approached this honorable court, the honorable single judge did not issue notice to. I was not arrayed as a party. I was the selected.
It was an order to pass the consideration to consider the representation. Where was Nick?
No, thereafter, next round of litigation, when the authority rejected his claim, he could not able to produce the certificate, and he has also admitted that I have applied, but I could not get it, madam.
Correct.
And thereafter, he approached for this honorable court for the second round, and wherein the select list was already final, and I was placed in the second serial number 2. And when the candidate at serial number 1 did not join in the post, then I would have been considered for that post. But when the respondent number 7 approached before this honorable court in second round, he had not hired me as a party to the proceeding, and I was not been noticed, and the honorable single judge disposed of the matter on Mr. 6, my lord. Kindly have a glance, ma'am. Page 25. Saying the order was quashed, my lord. I am placing the operating portion.
You are not a party.
No, my lord. Paragraph 5, my lord. Page 26.
You are not a party. Take out Shudev Singh, 63 or 64 Supreme Court. Take out.
Our High Court also.
All right, we will go to Supreme Court judgment now. You have to file review there.
The High Court.
We have that. Take out Shudev Singh versus Swines. No researchers in our court hall. Where have they gone? In seconds it should be.
SU case DBO.
Shudev Singh, SHIVEO. Shudev Singh versus so and so. Constitution bench judgment. 63 or 64 Supreme Court. State correct. 63 Supreme Court 1909. Apex Court says in such circumstance, you should file another writ petition seeking review of the order passed now which you have put in challenge before us. You can't maintain an appeal at all. You should file. You have to read the judgment. Then you can say no, yes, etc. If you say no, I will say no. How that's going to improve the knowledge?
I am not saying no, my lord. Our
we have understood the case now. Unless you read this judgment, we will not permit you to argue further. We cannot waste our time that way.
Let it come some other time.
That we can understand.
But 1963 Supreme Court.
AR 1963 Supreme Court 1909. You should not quarrel with the judges on oppositions.
I am not quarreling.
If judge says something, you should be in a position to counter the judge. That's a great thing.
No.
But without seeing a particular
our High Court rule also provides chapter 15.
Whatever this is what Apex Court has said in similar matter.
The problem is
it's a constitution bench judgment.
The court granted directed for opportunity of hearing to you who will be affected.
That's one.
Yes, ma'am.
So you are not the number one candidate.
No, number one.
You are number two.
Yes, ma'am.
This person with MCOM degree became number one.
Yes, ma'am. Subsequently, ma'am. No, he was not the number one.
You are not. If you can rewind what I said, you can get that question clearly. You are number two. Number one did not join
at all.
Yes, ma'am.
So instead of number one, this person is now number one.
Yes, ma'am.
He has lectured over you.
Taking into consideration
in any event, you are number two and he is number one. So in the proceeding subsequently, they took into consideration MCOM mark sheet. What is the net result? You are deprived or he becomes number one?
Now
you just look into that judgment,
yes, ma'am,
and come back.
And now another development has come, my lord.
You come back.
You read that judgment.
Yes, yes.
We may be wrong also. We are suggesting
always try to
some research.
This is not the point. Not the judgment.
When you say something, one thing we request you, you should believe that judges of this court are not drawn from kindergarten. They have put in long service, long practice. Then the president of the country has appointed us. Therefore, when we say something, you may presume that it is like that. We may be wrong also. If we are sure that we are wrong, we are agreeable straight with. But whenever we have said some rulings, glance them. That will help you. That will help you. You are all learned members. This is a noble Cicero. Marcus Tullius Cicero called this profession as a noble profession because the knowledge is celebrated here. This is a marketplace of ideas. Is it not? Not a marketplace of fighting. It's a marketplace of, it's a war of wits. Therefore, we request you, because we have come across certain decisions. That's the reason. Yes.
Item 18.
Yes, sir.
Already in this appeal, I challenge the single judge Millard. In which Millard, the honorable single judge failed to mark that Millard.
Can you use the microphone?
Millard.
What has happened to our mic? Cases are weak, voices are also weak. Yeah.
But in this case, Millard, I am challenging the order of honorable single judge Millard. On the ground that Millard, the honorable single judge failed to mark that Millard, that the disciplinary authority and the appellate authority is the one and same person.
One and the same person.
Same person. And the charges that was not framed in the Millard during the proceedings, that was Millard taken into consideration and stated that it. And your lordship, can you have a glance that the person.
So these grounds where you have taken in the writ petition.
Millard, in the writ petition, I have Millard.
Page paragraph. Maybe original application it was. Then WPC OAC.
WPC.
So which paragraph? These two grounds.
Well, that is apparent from the record also, Millard. Because your lordship.
Correct, sir. Because they have to respond to that. Because on that score, you will win your case. So when you say that the appellate authority and the original authority are same, or the appellate authority or he has usurped the power of appellate authority, so they have to deny that.
Yes, Millard.
So why you have stated? Because the same question is for them also. That you must realize, which inures to your benefit or your buttresses your argument.
Millard, your lordship, page 27. This is with
Can you the paragraph? Can you see the paragraph? Because it's not page mark that way. With petition 1, 2, 3, 4, 5, 6. And regarding memorandum of charges also, that which charge was proved without being mentioned in the imputations. So because it ends at where you have to. Can you suggest the paragraph?
That is in paragraph 611, page relevant page is Millard. 40. The applicant humbly submits. May I read, Millard, that?
No, writ appeal, you have not enclosed the writ petition.
No, I have not. Only
so refer to the writ petition, writ petition column. Yes. 6.11, I have not found. If you have found, then kindly press it. I have not found 6.11 ABC.
Millard. 6.11 is at page 38, Millard. 11A.
30, not 38.
38, but relevant page is Millard, page 40. Second paragraph, that applicant humbly submits that. Page 40, your lordship.
It's not 40, it starts at 30. Because you are saying that you have not annexed. So writ petition, it is page 30, whereas 611A.
Millard.
So page 40 is not there.
Page 32, your lordship. Internal page
30. Paragraph 6.11A. You stick to the paragraph. Your page mark is incorrect.
That applicant submits, your lordship, that is 611.
What is wrong with this? 34 lakh, etc. was the loss.
No, Millard, that was not lost. The finding of the inquiring officer is that there was no loss at all to the state government, and it is recoverable as per the VAT Act. because the Back Act rule, my lord, 80, the 79 of the Odisha Back Act, my lord, if any anything, my lord, missed, or if any cell tax officer has missed, my lord, to assessing that officer, assessing that particular period, it can be, my lord, by way of audit account, it can be, my lord, made 42A. 42A of the, my lord, OBAT Act.
What is that? Odisha Value Added Tax.
OVAT.
OBAT, my lord, Odisha Value Added Tax Act. So, my lord, the finding of the inquiring officer, I am, my lord, just pointing out to that effect, my lord.
No, inquiry officer was favorable, held in your favor, but thereafter the disciplinary authority did not agree with that.
Agree with that.
Therefore, he gave an opportunity to come out with your representation.
My lord.
Having considered that, they have said like this.
My lord.
10%.
10% of the, my lord, the entire amount.
And one increment eternally.
My lord, that was there. And now they have, but they have did, my lord. In the finding itself, they have stated that, my lord, this person, there is no loss to the government at any point of time. Because the government can also recover the same by way of, my lord, audit assessment. And so far this petitioner is concerned, my lord, he has no role to that effect, my lord, causing loss to the government. Because he is the, my lord, the allegation is that, my lord, being a commercial tax officer, he has issued the registration to the dealer. In fact, my lord, he...
way bills. 45 so it's not regarding registration. Because of the way bills. No, I am saying I am not interrupting you. Since the facts you are not placing which are on record.
No,
then I have to come to your aid and to the aid of the court. So it's not a question of issuance of registration, VAT registration. Way bills are issued by you which has resulted in evasion of tax. Which you say that it is otherwise recoverable after evasion. So evasion you admit.
No, my lord, evasion not admit because I am not the person. My lord, I am not the person to issue the way bill also. Because it is the, my lord, assistant commissioner.
Taking note of your submissions, this court directed for filing of affidavit on this specific aspect.
Yes.
So that is at page 127 of the writ petition, affidavit filed by the opposite party number 1.
My lord. They are also stating that
Secretary of Finance, on behalf of the Secretary of Finance, look at the order dated 19th of February 24, where this court directed.
Miller.
ଆପଣ କାହିଁ ବସିଛନ୍ତି କେସଟା କାଢିବେ ନା ନାହିଁ ଜାଣିପାରୁନାହାନ୍ତି ଯଦି ଆପଣ କହିବେ ନା WPC OAC କ୍ଲିକ୍ କଲେ ପେଜ 127 ମୁଁ ଲେଖିକି ଦେଲେ ସେ କି ଜାଣିନାହାନ୍ତି ବୋଲି This is the order. Para 2 of the affidavit, para 2-3.
Loss of 34.61 lakh.
Yes.
To the exchequer.
234.
That is, my lord, page 70.
117.
My lord, 73. 73, my lord. 73.
73 in the writ petition.
Yes, my lord, writ petition.
Of the writ petition.
And relevant is, my lord, 74, relevant paragraph. 74 of the writ petition, my lord.
Page.
The dealer was issued way bills after the dealer fulfilled the conditions.
The disciplinary authority.
Without, my lord, any finding to that effect, why he is not, my lord, agreed? It must be with a reason, my lord.
No,
he cannot, my lord, just say that, yes, I am done.
Correct, but notice was given to you.
My lord, I have given, pursuant to that notice, I have given my explanation to that effect, but that was not considered. That was not considered and that order was passed, my lord. And his...
Where have you stated no loss is caused to the state in your representation?
My lord?
Where have you stated?
My lord, my representation, that is, my lord, you are saying that.
One sentence you showed that no loss is occasioned to the exchequer.
Page 91, your Lordship may see that. That is my reply to the complaint.
WP.
Yes, writ petition.
Read. Where you stick? Just read.
Since the assessment was getting time back, under 46 of the OBAT Act, the assessment was completed after examination of the aspect of allegation of a vigilance report by cross-verifying the purpose of allegation with the books of accounts and after considering the points of rebuttal raised by the dealer company. That after considering all aspect written submissions and facts available on the record and after being satisfied with the book of account produced, the assessment was completed as per provision of Section 42 of the OBAT Act 2004.
Where is that sentence which says there is absolutely no loss caused to the exchequer? One sentence we are asking you.
But that is their finding.
The finding
of the inquiring officer also.
Inquiry officer.
And my lord, that part also, my lord, I have dealt that paragraph G, my lord, that it may kindly be appreciated that assuming but not admitting that the assessment order passed by me be erroneous and prejudice, then there was remedial measure available under Section 79 of the Orissa VAT Act. In Section 79 of the Act, which empowers the Commissioner of the Commercial Tax or his delegated authority to initiate suo motu under Section 79 of the Orissa Value Added Tax Act. In such power has been exercised by notice dated so and so. Thus, there is no element of a loss of revenue as alleged or otherwise.
No, your assertion that there is no loss is on the assumption that there can be reassessment proceedings, review proceedings, etc.
Miller, there is a provision under Miller Orissa VAT Act under Section 79 empowers Miller authority. If there is any evasion of the tax by any dealer,
they can take up fresh.
They can take up Miller the recourse of that Miller.
Have they taken up? But there is limitation for that.
Yes, there is limitation of 5 years.
5 years. But how many years have elapsed now? Of which year?
Well, by the time that assessment was there was no the period was not lapsed.
Mr. Das, let's look at the imputation of charge. The charge is regarding issuance of way bill without compliance of 81(4)(b). So that's what is your answer to that?
My answer is that
what you are saying that
not the person issuing at all. That's what he is saying.
That's the word.
Who issues? Where is your job chart?
Millard, I was Millard CTO. Your Lordship must see that 80 section Rule 80 of the Orissa VAT Act.
Rule 80. Kindly read.
Millard.
Any job chart is given to you that these are the things you should do. That would be a guess because he has himself signed and issued. That exactly is not your stand, Mr. Das. Don't fall into that trap. That I never issued because you have signed it out of. So
yes, Millard, I have given that. But thing is, Millard, as per Rule 80, it is the Millard Assistant Commissioner who has to issue that.
But you have issued.
I have only handed over.
Millard,
as per the direction of the Assistant Commissioner of the Millard Sales Tax, I being the Millard the subordinate, then he directed me to hand over the same to the Millard dealer.
Hand over means the postman handing over the money order or signing, etc. You have done something there.
No, it is signed by the Assistant Commissioner.
All they are signed by the
Assistant Commissioner because your Lordship may see that who is the authority to pass away.
Your case is that you never issued anything. What is their response in their counter or in the?
They are stating that you have issued. Well, though Millard, the rule is otherwise.
No, rule may be something. We are not going to know whether you have issued or not.
No, Millard, I have not issued.
That's what you are saying.
I have denied it past page 128 because actually you invited this affidavit. I don't know. This affidavit. You see the order dated 19 February 2024 in WPOS.
We can't find the fact whether he has issued or not, how writ court should judge.
We cannot.
We cannot undertake that.
From that,
So one thing you can do, that any one line in your defense that you have not issued, or before the appellate authority, after it shows, the disciplinary authority issued you a second show cause differing with the finding. Correct. In both the show cause affidavits or your response, you have stated that I never issued 340.
No, he admits that he has issued it. You have admitted. You issued it on the instructions of the higher up.
Yes, I have admitted that it is issued by.
So written instruction or anything what stand you have taken that you have produced that I never did it. The problem is that recovery part is not the allegation.
No, recovery.
Suppose the allegation is that there was evasion of 85 crores of tax. It's 85 crores is a hypothetical amount, 8 rupees of tax. And it could not be recovered due to your negligence. That's not the allegation. The allegation is that you issued the way bills.
Way bills, yes. 350 sets of way bills.
To verifying the state tax compliance.
It's not.
It's a very specific allegation.
Specific allegation is that.
Serious allegation.
Malad.
So,
but your lordship may say that as per Rule 80,
Rule 80 provides that the assistant commissioner should issue that one. You are not the person.
Not the person.
Question is not rule.
Malad.
Question is whether you have issued or not.
No, Malad, I have not issued.
Why you have taken that stand?
Malad, that stand I have already taken in my counter as well as
not counter.
In the petition also, Malad.
I have petition response from the authority.
Shokas, your reply to Shokas notice.
We are not appellate authority.
Malad.
The fact finding part where the disciplinary authority continued.
Yes,
there you have taken that stand and they have not considered.
Yes, that stand also, Malad, I have taken, Malad. That
so
stand I have also taken, Malad, in my Shokas.
Otherwise, the state exchequer, who will protect? This state is not that rich. And unless the money flows from the taxation to the exchequer, the development activities cannot be taken at all. Therefore, the authorities are very strict in respect of that. Otherwise, tomorrow every officer will take such a contention. Where from the money for the state?
Paragraph 7, page 49.
But it's not matching. Your first of all, you find out the annexure which you have annexed, which was the show cause.
Let him read it.
Read it.
I'm reading that. That allegation level in para 3.4 of the statement of imputation of the misconduct in support of the article of charges is not correct and hence denied. It is humbly submitted that the dealer was not issued on one book of way bill at the first instance. The dealer was issued way bill after the dealer fulfilled the condition laid down under Rule 84 of the Orissa Sales Tax Rules, that is 2005. Moreover, it will be presumed to come to a conclusion that dealer has evaded tax before completion of audit assessment and before invoking the remedial measures.
You don't have to read, but
you have admitted that
it was issued. You read where you have stated that no way bill was issued by me or no way bill was issued.
No, Milord, way bills were issued. No doubt, Milord, way bills were issued.
What else in
350 way bills were issued. But that is issued as per the assistant commissioner and as per the direction of the assistant commissioner, because I am the person to hand over the way bill to the concerned dealer. Because assistant commissioner will not come to hand over the way bill to the dealer. But he only signed and it is mailed through the Batis software. In the Batis software, he signed the same and sent to me. That is mailed through online. And that is mailed, I will cross check and hand over that.
You should not have handed over.
Yes,
you should have said.
You
should have said, sir, so much money is due. Unless that compliance is reported, we cannot issue. That's your duty. That's the reason why the whole process is structured that way.
Yes, but my lord, that the rule does not provide my duty to that effect that I should scrutiny or cross-check. That is not rule there.
All right. What is your designation?
My lord, I am a commercial tax officer.
Then that by designation your duty arises. You are not some FDC. STC saying that I will obey what they will say, I will close my eyes, I will hand over the golden apple. Is that not the way? That's not the way. You are an officer of the higher rank and you exercise quasi-judicial powers. Therefore, you should have, if we had issued, immediately you should have said, sir, so much amount is due, we cannot issue that, reconsider. If you have put that note, that would have come to your
so far way bill is concerned, Millard, at that point of time, Millard, what is happening, Millard? At that, Millard, at that,
I have heard you as if this is an appeal virtually, because we did not want to put anybody to injustice. Therefore, we overheard you. You performed very well. But case is big.
No, Millard, your Lordship, there is two grounds, other grounds also, Millard. Your Lordship may say that the disciplinary authority, he has inflicted the punishment. And he became the Millard appellate authority and confirm his own order. Your Lordship may say
in
that. Appeal. Your Lordship may say that.
That is the strongest point. You should have argued it.
Millard, first point, in fact, we asked you also.
Millard,
That why
you
are yet to state that.
Millard, Annexure 5 to writ application, your Lordship may see that Annexure 5 is the passed by the disciplinary authority. Order. That is,
but
Millard,
that contention you did not take up before the single judge.
yes, Millard, that is.
But that has not been reflected in the order.
Millard, the Honorable Single Judge held that even after that, as there was a vigilance case is pending against me, that's why unless and until that vigilance case is culminated, then I cannot raise all those things.
No, according to you, who considered your appeal? According to you, who considered your appeal?
Same officer.
Same officer, Millard, your Lordship may see.
Governor.
No, Millard, your Lordship may see that Annexure 7. That was not.
Kindly look at the Annexure 7 bottom.
Millard.
Page 94 in the writ petition.
Yes, Millard.
Yeah,
in consideration.
No, sorry, I'm so sorry. Actually, I have to instruct him. He is an expert of our, he doesn't understand my language. So please don't get distracted on this, but I'm sorry.
So 10% of the by order of the government. Additional Chief Secretary to government. What the original order was passed by
Additional Chief Secretary to government, you'll also see there Annexure 5, page 83.
Allocation of business rules. Transaction of business, allocation of business rules in Orissa.
It is there.
It is there.
Government of Orissa rules of business.
Rules of business is there.
Rules of business are there.
Yes.
But if he is the same officer, then he gets promotion. Then he passes an appeal order. It's a governor never does things. In fact, Maruram, is it in under the rules? Appeal governor Apex Court said in 1980 Supreme Court. Apex Court said in Maruram versus Union of India, perhaps.
Yes,
correct. That's the judge. Governor is a shorthand for the government. President is the shorthand for the central government. So wherever there is an order passed by the governor, it is an order by the government itself.
That matters.
Correct. Now, how very same officer would consider the appeal? That is appeal from seizure to seizur's wife. That is not permissible. He himself sat in appeal.
Same person. Judge of own cause.
Yes, how?
Again, Nagapalli.
If we sit in appeal over our own orders, what kind of appeal it is? Governor of it.
Wait, about 2 pages back. Chorane Pustale. 94. Last one. Government has increased to order.
Yeah,
next one.
But same authority officer.
Next one.
No.
You produce the file. You produce the file to ascertain whether he
Whether that
participated.
person is here the appeal or same
Just
person?
shows, that's all. You can show it to him also. After all, there is nothing secret.
After you bring it, seal cover or whatever, you can show it to him. He will be satisfied also.
Learned counsel for the appellate, apart from arguing several points, pressed the main point that the original order of punishment was passed, and that was carried in appeal in challenge. First off, he adds that the author of the original order and that of the appellate order are one and the same person, and this is violative of nemo judex in res one principle. So he has to I also nemo judex in res one. Res one. Number one is there also. Sort of one is first. A person cannot be a judge in his own cause. First. To next paragraph. To ascertain the truthfulness or otherwise of this assertion, the respondent government is directed to show us from the original records of the proceedings concerned on the next date of hearing. First, failure to do it may result into an adverse inference being drawn against the government and in favor of the employee. First of all, call this matter on 25/7. We have heard the entire matter now.
Let's keep it on August something.
Well, it has to come how many kilometers?
I'll write a letter.
Does it come by road roller?
No, I'll write a letter and government will
25/7. 25/7. You can bring the papers, the Xerox papers also to show that entire this one. It is open to bring. It is open to bring photocopy of the original, if necessary.
Or if they scan it and send it to you, it will be much faster.
That will be.
I'll take a print.
I'll arrange.
Or straight away you can put a pen drive here, scan copy.
Let us.
May I make a mention myself? Item number 24.
24.
I have the respondent have taken consent of an unenfranchised appellant. I have misplaced my bill. Can it be taken up next week?
Next week?
It's not possible, sir.
Sir?
Week after next week.
Next week.
Week after next.
Lawrence Junior can take the court brief. Pen drive also.
I will arrange it and take 1 or 2 days time.
No problem. Yes, week after.
The state preferred the single liquidations against the judgment of acquittal under section 302, 201, 221, 20, 34 IBC. The case is based on the circumstantial evidence. Weapon has been recovered from the accused premises, and it's leading to discovery. The accused has shown that he has kept the weapon
from village Nala and.
What is that weapon?
That is Gupti, Bhujali and axe.
Three weapons.
Yes, 3 weapons.
So one is axe, one is a small kind of very knife.
Okay.
And it is based on the substitute
a white knife.
Okay. Like machete.
Yeah.
Yes.
Let's.
So did you link that those weapons with the injury by medical evidence or forensic evidence?
There is no proof of assault in the axe, but Gupti is there, stabbing injury is there, and lacerated injury is there.
If it is discovered at a place like a Nala, so it becomes very difficult that to prove, because no one would have interfered with that after he kept it there. Suppose discovery. We need to what is the best evidence you produced in the prosecution, according to you?
During the Miller's confession, accused has shown that weapon has been kept in.
Inadmissible evidence.
That is admissible under the 27 Miller.
Not
that part only.
Culpable part is inadmissible. Only that part.
That part is admissible.
I have. This is discovered. Even I have kept the weapon cannot be admitted.
Discovered used in the crimes.
Sorry.
Used in the crimes.
That weapons used in the offense. Discovery of offense used in the offense.
To that extent, it is admissible. To that extent, it is admissible.
In self-inculpatory part will be excluded. Look at 25.
The 25 and I have one judgment. You should see that judgment.
So how the court has dealt with that?
That court that it is not admissible.
Correct. So that's the correct.
Not admissible, na? Even otherwise also.
One judgment you have to see that.
Knife is discovered.
Yes.
That is admissible.
That is admissible.
But other inculpatory statements cannot be admitted.
Cannot be admitted because he has confessed that he has committed murder. Both the accused confessed before the police. That is
before the police.
That is inadmissible.
That is inadmissible.
During the custody of the
you give 2 police people to me, and any hardened criminal, I will see that he will admit to everything. That is no confession. Confession made to a person in authority is inadmissible in evidence.
And both the seizure witness of weapon has been become hostile, declared as a hostile, and thereafter suggestion has given by the public prosecutors. We
will look into it. Come back. We don't want to hasten in this matter. We could not go through on this matter in the first week of September 2025. Let us see.
Leave this yet to be done.
Not much.
Smaller offenses, because the rigorous the offense, then the rigorous the proof, then the quality of evidence.
So far as witness is concerned, that nobody supported the prosecution witness. Only police and doctors as well as.
So Mahanti could not prove the recovery, and you could not link the weapon to the.
Was Miller's prove the recovery become
because you are saying
hostile. Yes, that becomes a challenge there. That is the case, Miller. Chain has not been completed here.
Yes.
Item 23.
22 actually.
Item 23, my lord.
Yes.
State before my lord the leave petition against the order of tutor passed by the learned session judge Kenzor, my lord.
No notice is ordered.
Notice has been issued, my lord.
Notice is served on them.
My lord. They have appeared also, my lord.
Let us see.
They have appeared.
So David Prasad, my lord, notice. None appears for the accused when the matter is called. The institution informed the Learned Council on record. Last week, August period date follow the time much.
29 August.
29 August.
Item 23.
26. Item 26, my lord. I am for the appellant.
Item 26 on behalf of Ms. Jena. This matter may be adjourned, my lord, because she's on her feet elsewhere. She's not able to attend this matter personally.
When do you want Mr. Das?
My lord, here is the case like the other case, my lord, was gave opportunity to parties to stay together. Here is the similar fact.
But his friend has to come, parties have to be here.
Yes, my lord.
To keep parties, but a lot of time we are spending
Yes,
in
yes.
these matters.
Yes, yes, that is what
We are questioning ourselves. Are we doing right thing? We are spending almost 40 minutes with this case.
But there is every possibility of a reunion. What I found. Here in my case, my doctor, the wife has come up actually. She doesn't want to take divorce. She says that I have married once, I will not marry again. Now, whatever alimony you want to take the alimony, leave that guy. But she doesn't agree in the same. She requests that
Keep both of them present before the court.
yes, my lord, if matter will come up on any other day,
Yes.
the council will present that thereafter will instruct. Well, in this case,
Can you inform
Yes,
that for a personal appearance court has directed?
yes, my lord.
Or will
The present petitioner is the JNM student fellowship. They admitted in the JNM course fellowship 2016 and 17 batch. As per guidelines fellowship, he has to complete the course within 6 years fellowship. 3 years course, maximum within 6 years he has to complete the course fellowship. Accordingly, the first year, first examination, he has succeeded. In second examination, she has succeeded. In the third year examination, one back paper is there, failed in one paper, LRC.
supplementary system is not there?
Yes, yes,
Right,
that is there.
And
Supplementary is filled up. Supplementary examination, it took up.
Yes.
Because
Subsequently,
after
yes.
3 years, there will be no back paper because you have lost the completed 3 years.
Yes, yes.
It has to be only supplementary.
my lord.
So you understand what I'm saying?
Yes.
Yes.
That subsequent 2 years, the COVID started. During COVID period, she has also appeared in next 2 years, LRC, but could not succeed. And her last term was 22 and 23 year examination. Last term was there. But after 11 years of marriage, she conceived in that year and gave back to the child on 12/2/2023 LRC. So she could not appear in that examination.
The COVID period exemption was granted.
Yes. There was
That period examination was here and she appeared.
Exemption after grant of exemption. So what is the total period consumed?
more than 6 years.
More than 6.
But she has cleared the examination.
No, my lord, not
She
clear.
is not allowed to appear at the examination.
In the last, her last examination, LRC, she could not fill up due to his health issue. That is, she was conceived and gave birth to a child on 12/2/2023 LRC.
Whether rules provide relaxation for the pregnancy and childbirth,
No, that rules was not
nothing
there.
can be done. What can be done?
Sympathetically, LRC may
It is simple.
allow
Once
the
we do it
future of
sympathetically,
a-
it becomes right for rest of the people.
No, no.
And this judgment will be circulated all over the country.
So only one chance,
No,
LRC.
Mr. Barar,
No.
you have to examine this way.
Yes.
Sir, in Delhi University, it is 5 years. Vice Chancellor has capacity to grant 1 year. If there is any such capacity to grant pardon, then
Any
But
power to
justice.
relax.
Not
beyond
like
6
Delhi
years.
University, so the maximum period to complete 3-year LLB is 5 years.
Yes.
Beyond 5 years, we are not allowed. Then 1 year, only at the discretion of the chancellor.
That
So
was my
suppose,
learning in
I mean,
the-
that's kind of a mercy petition. It is in fact called mercy petition. So that way, if you invoke that, they may consider that's a different thing. But as far as court is concerned,
We cannot do. Because there is judgment of the apex
so
court.
many judgments.
Many
Yes,
judgments.
that is there, LRC, but here a counterfeit filed by my senior LRC for the council, there is 6 years is there, LRC.
That's all. Our syllabus says 6 years. INC says 6 years.
6 years within 6 years.
Indian Nursing Council 6 years, syllabus is 6 years.
6 years. Last year
It's a
we
3-year course.
3 years course.
So first set 6 years will be given.
Yes.
And beyond 6 years, nothing can be done.
No.
COVID you were saying?
COVID not exempted.
Schedule.
COVID period not exempted, but the college has examination.
We had examination in COVID period from 2016 up to 2024. We have all the exams supplementary, and when there is supplementary needed, we do the supplementary. Otherwise, annual examinations. There is no stuff.
Nothing can be done.
If you want to examine, can you come back tomorrow that if any clause is there?
No class.
No class.
Nothing.
In the advertisement there is no class, but due to maternity ground ownership, after 11 years
No, that is not recognized.
that
Maternity leave should be given is one thing.
yes.
But examinations, we cannot do anything. We cannot do that way.
For that purpose only.
What is the response that whether they have any power to relax
No, my lord,
in exceptional cases?
No, my lord, in the case, if we allow once from our side, then their floodgates will open. If my lords will give an exceptional case, that's a different issue. Otherwise, if we do, it becomes a problem.
The short grievance of the petitioner.
Real or to one chapter, I'll examine on that point.
You want to examine? Call in first week of August at the request of arguing counsel for the petitioner. Covered by the judgment.
And please examine that COVID period and matrimonial cause for, maternity cause for a student.
But maternity is subsequent to COVID period.
Subsequent to COVID period.
Nothing like that. Nothing.
I think she did not appear in supplementary. Initially, did she appear in the supplementary?
She appeared in the
Mr. Mahan repeatedly saying, although while they have been conducting all examinations,
2 chances we have not done supplementary. That all examinations we have conducted. That I have got the list.
Yes.
Item 30.
May I, Lordship? Since 2014, I have no power supply in my residential house, my lord. Lordship, kindly glance the last order dated.
You are in darkness now.
Yes, ma'am. Since 2014. Lordship,
2014.
My lord. Lordship, kindly glance last order dated 27/1/25, whereby my lord has given Lord, an advocate appears on behalf of the appellant who was read petitioner. He submits the appeal has been preferred against order dated 6/5/2024 passed by the learned single judge erroneously.
You have not paid arrears and therefore they have done that way. That's the standard.
No. The arrears should pay by opposite party number 7, who is my brother. I have no, since 2014, I have no electricity. I have already separated from my brother, residing in one roof. Thereafter, I applied one Pradhan Mantri Awas Yojana.
Earlier you were together.
Yeah, before 2014, we were together.
1 second. A Hindu family is presumed to be a joint family.
Yes.
Correct?
Yes.
And that property is held in joint.
Yes.
Do you agree?
After death of my father.
After death of your father.
After death of my father, page 51, Lordship, I can kind of glance.
Yes.
They made one agreement separated between 2 brothers. Page 51, my lord. On 23/7/2014, I have already separated from my brother.
Where is that?
Page 51, that is Odia, my lord can see.
What is that? Partition deed?
Yes, this agreement already separated from my.
Is it a partition?
Yes.
Is it true?
Is it a registered partition?
So partition deed.
Where is that partition?
Suppose assuming that you parted separated, how will it impact the electricity connection?
Because, my lord, because that electricity was before 2014.
That is arrears.
Electricity was 2014. The arrears came to my brother, who is enjoying now. I have no electricity since 2014 in my room, in my residence. That is my prayer. In 2018,
Did you apply for a connection?
Yes. Yes.
Connection, Mr. Marana?
So, may I just clarify subject to?
This arrears is for what period? Pre-partition period or post-partition?
I'll just appraise that particular.
This is the only question.
Yes, ma'am. Apart from that, I'll answer the question. Before preferring the writ petition, which has been subject matter of challenge in this writ appeal, the petitioner with the self-same ground had earlier approached this honorable court in a writ petition, wherein my learned senior said the arrear claimed is 25,000 some odd amount. We came in fairly admitted that it is not 25,000, it is somewhat 14,000. My learned senior prayed before this honorable court that he is ready to pay it. And suitable installments are to be young so as to enable him to pay. The honorable judge, honorable court, after considering our submission and on the prayer of my learned senior,
that order,
page 36.
This is in the writ appeal.
In the writ appeal.
First writ petition.
No, it is 222. It is 36 of your lordship's brief at the writ appeal.
Yes.
Running page 36.
Yes, my lord. Para 5.
If the petitioner pays, then you will review the power supply.
My lord, that has to be. This particular order, my lord, has not been challenged.
My lord, kindly have glance to para 6 also. Para 5 and 6 also.
Five and 6.
5 and 6 and top of the list, submits, top of the line, first submits. That outstanding is not to the tune of rupees 25,842, but it is rupees 14,729 in respect of the said premises in view of the regulation 79 of the OERC condition of supply code.
Monthly installments given.
My lord.
So you did not pay anything.
My lord, kindly have a glance to the rule 79. What is he saying?
The problem is that
you have agreed. This is your.
I am not residing in my premises, my lord, since 2014.
You should have.
No.
You have suffered an order.
Because also kind of glance to the notice. Who is getting the notice to pay? Who is the successor of the electric supply?
1 second.
Yes, my lord.
You filed the writ petition.
My lord.
You suffered this order.
I support this order subject to because my friend submitted in court that some outstanding amount is pending with me.
Yeah.
That is why I supported this honorable court's order. Thereafter, my lord,
filed appeal on this.
Thereafter, I filed WBC number 10709/2024, Lordship, page 76.
This order has not challenged.
This order you are not challenged.
This order, I have not paid the outstanding dues of 14,729 because I am not the successor of that.
No, you can't say. Once order is made, you cannot sit in appeal over the order.
Why your lordship, I will pay? Because why I will pay?
Mecca by asking questions to court.
My lord.
Suppose you ask for money that 14,000 lordship may keep, that's another thing. But please don't ask questions why I will pay. Because you see, you have preferred to be in darkness. They continue to be in darkness and asking questions to the court why I will pay.
Because my lord, so 17 why what he said?
You are the petitioner, even Mr. Mehta. You are yourself is the counsel in that writ petition.
Well, I am clarifying, my lord.
This would amount to every day a petition being filed and every new order is being passed by.
I am clarifying, my lord.
How can we clarify the earlier court?
17 I also kind of glance.
The petitioner will clarify the court's order.
No. My lord.
The same petitioner also, Vishwaranjan Mahanti.
Because I filed due to outstanding dues against me, that is I filed the writ appeal, my lord. 10709. 79 speaks. 79 case, my lord,
This order.
Due to non-payment of outstanding dues, I filed
WPC number 10709 of 2024.
We are again asking you.
My lord.
Have you challenged this order?
Yes, in WPC number 10709.
It cannot be WPC because this order itself is in WPC.
Yes, my lord.
An order in WPC cannot be put in challenge in WPC only. That's our impression. We may be wrong also, we do not know. But that impression will be reflected in the order.
I filed WPC, though Honorable Court directed me to pay the outstanding dues.
So, brother,
non-payment of
there is a direction. Kindly come to para 5 and 6 now.
My lord. My lord, I pray, my lord.
Judges have to convince the lawyers before we pass the order.
I pray, my lord.
That level court has come.
I pray one thing, my lord.
Yes.
Page, Lordship, kind of last page.
Sir, will you not look at the order even? Can we not make a prayer to you to look at a High Court order where you are the petitioner?
Yes, I oblige, deeply oblige, my lord.
I'm indebted. Please look at para 6.
May I pray page 70?
No, please don't pray. Just look and read.
Para 6.
Yes.
Taking into consideration the submission of learned counsel for the petition, this court is of the considered opinion that in view of Regulation 17I of the OERC Condition of Supply Code 2019, as stated above, no power supply can be given to the premise in respect of which there is any outstanding of electricity charges.
Can I read further? Don't obliterate part of the order. There is also a further prayer from us. Taking into
consideration the financial condition of the petitioner and the submissions of learned counsel for the petitioner, this court disposes of the petition with the direction that if the petition pays the aforesaid arrear amount is to equal monthly installments, power supply shall be given to its premises on payment of entire area dues as stated above.
There are 5 of it. There are 5.
Para 5. Mr. Makeup Learned Counsel submits that the petitioner is a poor person and cannot pay the outstanding amount of rupees 14729 at a time.
He therefore
pays for direction to fix the suitable installments to pay the amount.
You have undertaken to make the payment if installments are given. We will tell them to give you installments.
Why I file writ appeal, my lord, on page 66.
Against this order.
My lord, can you see? Page 65. Page 65. Against this order, I filed WPC, page 65.
No, you have filed writ appeal against the order passing WPC 10709 of 2024.
Against 8322 by 2022, I filed WPC number. Though I not pay the outstanding dues 14,000 rupees.
WPC against a WPC. Is it WPC square or what?
The short grievance of the appellant is as to, we have heard it, non-supply of power.
He's putting the law into embarrassment. Your client, most favorable order, I mean, even 14-1, 17-1, it doesn't permit an installment. Strictly speaking,
because he is not.
So that was allowed also. Still, he doesn't want to help himself 7,000 rupees and getting something.
I proceed.
The short grievance of the appellant is non-supply of power to his premises. First off, in the earlier round of litigation, namely in WP number 8322 of 2022, there was a direction by a learned single judge of this court, by the order dated 30 August 2022, where paragraphs 4, 5, and 6 read as under. First one. Next paragraph. Learned counsel appearing for the appellant vehemently argues that by virtue of partition, the shares have been defined and that the amount payable is attributable to other sharers of the property and not his client. And therefore, the power supply company is not justified in insisting upon payment of arrears as a precondition for power supply. First of all. Next paragraph. Learned panel counsel appearing for the power supply company per contra submits that in view of the order dated 30 August 2022, the claim of the petition appellant is liable to be res judicated in view of decision of the apex court in AIR 1992 SC 101 paragraphs 5, 6, 7. First off, he submits that a wrong order is nevertheless an efficacious order, the same having attained finality, there being no further challenge. First off, we agree with this view. First off, we hasten to add here that in paragraph 5 of the said order, the easy installments were suggested by the learned single judge on the very submission of the appellant himself. And thus, appellant was a beneficiary of the said order. First of all. Next paragraph. In the above circumstance, there is absolutely nothing in the subject appeal, and the learned single judge's order is even otherwise not interferable. First of all, writ appeal rejected.